way the reasonable doctor would fix it. And so, when we're talking about the negligence of a professional in the practice of his or her profession, we say that a breach of the duty of reasonable care has occurred if that professional failed to act like the reasonable member of the profession. Now that raises a few problems, and let's talk about them. First of all, what do we mean by a professional? Is a bus driver a professional? Is a doctor a professional? Is a welder a professional? And of course, in the English language, a professional is anyone who gets paid for what he or she does. But when we talk about a professional in this context, in the context of professional negligence, we say that a professional is a person who pursues an occupation which is primarily of an intellectual nature, and an occupation that requires special skill and training. You know, a plumber spends more time learning how to be a plumber than a lawyer spends learning how to be a lawyer. That's true. It takes something like 20 years before a person is qualified as a master plumber. So certainly plumbing is an occupation that requires special skill and training. But plumbing is not an occupation which is primarily of an intellectual nature. What that means is plumbing is not primarily an occupation involving thought. It's primarily an occupation involving action. In fact, you know the old joke, they say a plumber really only has to know two things: water runs downhill and payday is on Friday. Of course, plumbers have to know more than that. But plumbing is not an occupation which is primarily intellectual. On the other hand, lawyering is, because lawyers do more thinking than anything else. Even surgeons who work with their hands, even dentists who work with their hands, do more thinking than they do operating with their hands. The occupation is primarily of an intellectual nature. So that's what we mean by a profession. The next problem that's raised by this special standard we have for professionals is this. If we say that a professional is expected to act like the reasonable member of his or her profession, how can we ask a jury to decide whether that professional failed to do so, when, after all, the jury is not likely to know how the reasonable member of the profession acts in most situations? Do I have any way of knowing how much penicillin the reasonable doctor would prescribe for my flu? Or where the reasonable surgeon would make an incision to remove the framus from my epiglottis? No, and so how could I decide that if I were on a jury? The answer is that in a case of professional malpractice, hey, professional malpractice, what's that? Professional malpractice is just a fancy name for negligence by a professional in the practice of his or her profession. In a case of professional malpractice, it's usually necessary for the plaintiff to produce the testimony of an expert witness to tell the jury what, in his or her opinion, the reasonable member of the profession would or would not have done under the circumstances. An expert witness, and you're going to learn much more about expert witnesses when you study evidence. An expert witness is a person who is so adept, so knowledgeable in a particular field that he or she is qualified to render an opinion. Ordinarily, people who testify in court are not allowed to talk about their opinions. Hey, who cares what a witness's opinion is? But an expert is a person who is so knowledgeable that his or her opinion is accepted for the purpose of guiding the jury in making a decision. And most of the time in a professional malpractice case, it's necessary to show through the testimony of experts what the reasonable member of the profession would or would not have done under the circumstances. Now, there's an exception to every rule, and there's an exception to that one. And the exception is when the negligence involved is within the understanding of the ordinary person, then it might be possible to try the case without expert witnesses. For example, if I'm the plaintiff and I'm claiming that the doctor gave me the wrong drug, or the doctor gave me the wrong dose of a drug, I'm going to have to produce expert witnesses because the jury doesn't have any way of knowing what drug the reasonable doctor would have given, what dose the reasonable doctor would have prescribed. But if I'm the plaintiff and I say my right leg was crushed in this accident, and when they brought me into the operating room, the doctor came in and cut off my left leg by mistake, the chances are I'm not going to need an expert witness to prove that case, because even the layperson knows that a surgeon doesn't cut off the good leg and leave the crushed leg in place. Of course, you know, if that happened to me, I'd probably lose my case anyway, because I wouldn't have a leg to stand on. Oh, this is getting worse, isn't it? I won't do that again, I promise. Just one more special rule that I think I want to remind you about or review with you in connection with professional malpractice, and this special rule applies particularly to medical malpractice. The rule is the result of a statute which is generally known as the Good Samaritan statute, and most jurisdictions now have a Good Samaritan statute, which is why you might need to know about it even though your torts course is generally concerned with common law. The Good Samaritan statutes in the states that have them usually provide that if a medical professional, a healthcare professional of some kind, happens to be passing an accident and stops and renders emergency aid without sending a bill, acts, in other words, as a Good Samaritan, that doctor or nurse or healthcare professional or whoever it is that's covered by the statute cannot be liable for negligence in connection with the aid that was rendered at the scene of the accident. So not all states have the Good Samaritan statute, but most of them do. And when you're talking about medical malpractice in a case involving emergency aid rendered by a passing doctor at an accident scene, it certainly is worthwhile to mention the Good Samaritan statute. All right, as I said earlier, whenever you're confronting the issue of breach, you'd better be prepared to argue about whether the reasonable person would have done what the defendant did. But there are a couple of special rules about establishing that a breach existed that I think we'd better spend some time on, and one of them involves the defendant's violation of statute. You know, we have lots of laws that tell us there are things we're not supposed to do, and usually the violation of those laws is a crime. And I told you in the beginning that we really weren't going to be discussing the criminal law. We weren't going to be discussing anything but the law of torts. So the question now is what relationship there is between violating those laws and the law of torts. And the rule goes this way. If a statute exists for the purpose of protecting a class of persons to which the plaintiff belongs against the kind of risk that led to harm in a particular case, then a violation of that statute may be negligence in and of itself, or may help in some way to establish that what the defendant did was negligent. In other words, if the defendant violates a statute, it's possible that the plaintiff can show that the defendant was negligent without ever talking about whether the defendant acted reasonably or not. It's possible that the violation of the statute is enough to establish negligence. When is that so? When the statute is designed to protect people like this plaintiff against risks like the risk that occurred in this particular case, whatever the case is that we happen to be talking about. And so frequently when there's a violation of statute, you're going to have to argue about what the statute's purpose was. Now sometimes that'll be given to you. Sometimes you'll be told this statute was passed for the purpose of protecting so-and-so against such and such. But very often you won't be told anything of the kind. And then you're going to have to make a logical argument about what that statute must have been designed to prevent. I'm going to give you an example. There's a statute that says that in places where the railroad tracks run across the prairie, the railroad is required to build a fence on both sides of its tracks. And in a particular case, the plaintiff owned a cow, and the cow was out grazing on the prairie. And the cow wandered onto the railroad tracks, and there happened to be poisonous weeds growing on the railroad tracks. Well, there were poisonous weeds growing all over the prairie, but they also happened to be growing on the railroad tracks. And the cow ate the poisonous weeds and died as a result of eating the poisonous weeds. The owner of the cow sued the railroad. The railroad said, well, we didn't do anything unreasonable.